good evening, and welcome to the Distinguished Lecture of the Global Trade Law Academy 2026, hosted by the Center for International Law at the National University of Singapore. I'm Sue from the Center for International Law. This event, the address and the Q&A with Prof. Gregory Schaefer will last for approximately 1 hour. During the lecture and the Q&A, our audience are invited to pose questions for Prof. Schaefer using the Q&A function that you will find at the bottom of your Zoom screen. So without much further ado, I'll pass over the floor to Professor Joseph Weiler, who is the convener of the Global Trade Law Academy.
Thank you very much, and welcome to everybody. So the international legal system in general and the international trading system in particular are under unprecedented stress. And in selecting the distinguished lecture this year, I immediately turned to Professor Gregory Schaefer from Georgetown University Law Center, where he's a chaired professor and has just stepped down as president of the American Society of International Law. Maybe I should say the American Society of International Law. Professor Schaefer is a distinguished scholar. He's published countless articles, no less than 12 books, makes me jealous. But I will mention one book in particular, which he published in 2022, a prize-winning book called Emerging Powers and the World Trade System, the Past and Future of International Economic Law. In looking at the past, I know of no book which does a better history and a better historiography of the international trading system. And in looking at the future, it is truly prophetic. So we are very, very fortunate to have Professor Schaefer as our distinguished lecturer this year. And Greg, I pass the floor to you. Welcome and thank you.
Thank you, Joseph, and thank you to all the sponsors and to the organizers. So I'm going to, we'll just start off by just saying that obviously, as Professor Weiler just stated, international economic laws, as law generally, is at a critical juncture today. And these are revolutionary times. And with the rise of the second Trump administration, which is aiming to completely undo international economic laws. In response, and even many critics of the international trade regime have felt at least partially pressed to come to its defense, including the BRICS countries, the Africa group, since the power-based alternatives to multilateralism orchestrated by the Trump administration is much worse than which previously existed. So in this talk, I'm going to focus on how we should think about the rule of law as applied to international economic law. I'm going to give examples from the current context, and I'm going to assess international economic law and note that doing so in rule of law terms is a very tricky matter, given the history of international economic law and critiques of biases in international economic law. To my knowledge, there's no systematic work on how to think about the rule of international economic law as a whole, although there is work on the rule of law and investment law, both positive and critical, and although rule of law slogans are tossed about all the time. So I build from my most recent book, which is The Rule of Law Under Pressure, a Transnational Challenge. And what motivated first me, why did I write this book? Well, I wrote the book both for normative and analytic reasons. The main normative reason was January 6th, attempt to use violence to overthrow an election in a democratic country, my own country, the United States. And the analytic reason was to ask, why do we see these trends happening around the world, in countries around the world? And then how do we think about the challenges to international law and institutions in relation to these rule of law challenges that we see domestically? So let me start by saying a few words, though, about the current context. And this turn in scholarship, you see it everywhere, to what's called geoeconomics and the logic behind that and the challenges it poses. So not so long ago, the dominant logic for studying international economic law was law and economics. The focus was on increases of social welfare through trade and investment. It was a heyday of globalization. If you studied law, the casebook started with this logic. For example, starting with the theory of comparative advantage, the win-win prospects of trade. Then there'd be a page or two in the casebook dedicated to the issue of internal distribution of gains and losses, of winners and losers. But this was typically done in passing, noting that states could take care of the losers from trade through tax and transfer policies. Now, this new logic that has displaced the former one is geoeconomics, and notice law no longer appears in the term. Or to use the catchword now used in the European Union from where I speak, it's about strategic autonomy. It's a logic that more think tanks, sinners, and lawyers are using. If one believes, though, at all in the role of norms and of our agency as societies in constructing norms, and one must see that in using this term and in using this logic, we also help to reproduce it, to normalize it, to embed it such that we all live in security states. Like a virus, this logic can infect everything. Moreover, as we will see, the logic can be used protectually and abused by autocrats for their own instrumental aims and whims. The threats of coercion, of so-called weaponized independence, surely are real, they're felt. And so there's a reason behind such instrumental logic. But it reflects a Hobbesian world that has nothing to do with the rule of law, and indeed threatens and undermines the rule of law, not only internationally, but also domestically. It's important, thus, to retain spaces, if we have any agency at all, spaces of communication within and across countries to construct a world that is supportive of the rule of law across levels of social organization. So now I'm going to turn to this paper. It's a paper in progress. It's in 6 parts. And we'll see, I'll get as far as I can, noting the time limit. But first, I just want to stress, what do we mean by the rule of law? Or what should we mean by the rule of law? Different actors put forward different conceptions of the rule of law. The World Bank earlier put forth a vision that focused more on creating certainty and stability of private contract and property law, and the elimination of trade and other barriers to grow the economy. The UN Secretary General focused more on human rights. The UN Security Council focused more on security and thus law and order. Outside of political and institutional actors, there's a huge philosophical literature on the rule of law with many different conceptions, with theorists ranging from conceptions that can be termed a thinner procedural approach definition of the rule of law to thicker substantive ones. Building on these definitions, international institutions tend to provide an anatomical view of the rule of law involving checklists, such as the Venice Commission's checklist regarding rule of law attributes. It's because of the variation in these conceptions of the rule of law that Professor Weiler's colleague Jeremy Waldron calls it an essentially contested concept. I think that this generally accepted view is mistaken, and that can lead to perverse outcomes. The concept of the rule of law then risks becoming one more tool in an arsenal of lawfare that opponents use against each other. Both Presidents Biden and Trump referenced the rule of law while attacking their political adversaries. And, of course, President and Chairman Xi Jinping pronounces his own vision of the rule of law with Chinese characteristics, where the Communist Party plays the prominent role. I suggest we have a different starting point, in line with the social theorist Martin Krieger and his work, which is more universalist in terms of the goal of the rule of law, while stressing that the means to achieve such goal must be attentive to varying local contexts and traditions. I start with asking the question, what's the point? The rule of law is a normative concept that has a goal and that can then be assessed in terms of actual practices in different contexts in light of that goal. The point of the rule of law is to temper the arbitrary, unbridled exercise of power. The goal of the rule of law is to oppose such arbitrary exercise of power by setting boundaries on and channeling powers exercised through known legal rules and institutions that apply to all. What matters, however, is the institutionalization of these norms so that they count as a source of restraint and as a normative resource for us, so that they become ultimately a culture of practice. Now, note that I do not define the rule of law in terms of legal compliance. Law and legal compliance, of course, are important, but law itself can be problematic, whether it be national law or international law. Think of the law of Nazi Germany, of apartheid South Africa, of Jim Crow apartheid's south of the United States in the 1950s. Or think of the Berlin Conference of 1885, which divided up Africa. It is thus critical to distinguish the rule of law, which is an ideal, from rule by law, using law to enforce one's aims instrumentally. If the rule of law then is about constraining arbitrariness, then it's fair to say, well, what's arbitrary? And there are different conceptions of arbitrariness. I think the best, in my view, is that what is arbitrary is power or decisions made in an unrestrained, despotic, and uncontrolled manner without taking into account the interests of those subject to power. But that too is abstract and only gets us so far as any abstraction. So in my view, it's best to turn to problems. That is, turn to asking what are the sources of arbitrary exercise of power that we want to check. And such a focus is essential if we are to address rule of law challenges practically in terms of the means to address them. So I'm going to set forth 5 sources of arbitrary power. I'm going to give examples outside of international economic law to set the groundwork for then assessing examples within international economic law. And I take this tack because for me, the rule of law is ultimately about protecting individuals and groups from the arbitrary of exercise of power. And IEL, as international law generally, is generally about relations between states, and thus it only indirectly affects individuals. Okay, so the first primordial concern, a source of arbitrariness, is where the wielder of power is not subject in practice to the law, its controls and limits. When the law does not apply to those who rule, autocrats can attack opponents with impunity. That's why the 2024 Supreme Court decision in Trump versus United States is so concerning, because it found that the court granted the president absolute and presumptive immunity regarding all official acts. Armed with this decision, President Trump now feels confident that the rule of law does not apply to him when he's in office, nor to his followers, because he can pardon his followers. This combination of immunity power and pardon power is extremely dangerous. It is concerning not only in the United States, but because of the U.S. power and its normative influence, it can be used as an example and a normative resource transnationally by others in power. A second source of arbitrariness is where individuals are unable to know and predict how power will be wielded over them. Is it because of these risks that many theorists define the rule of law in such terms as non-discrimination, relatively stable law, perspective, coherent, consistently applied rules of law? Particularly concerning is the risk of arbitrariness in the form of discriminatory threats and prosecutions against critics and individuals that have served in prior administrations, heightening alarm today. We are reminded of the autocratic trope, for my friends, everything, for my enemies, the law. A third source of arbitrariness is where the institutional machinery to protect the rule of law is controlled by those in power, so that individuals no longer have a place that they can really be heard, where they can inform, question, or respond to how power is exercised over them. This institutional machinery is essential to protect against arbitrary power. A fourth source of arbitrariness is where authorities do not engage in reason giving and issuing their decisions, which reasons then can be contested. Think of Carl Schmitt, the Nazi theorist, and his definition of sovereignty is he who decrees the exception. National security is the mother of all exceptions. When any and everything becomes a matter of national security and there is no judicial review or extremely deferential judicial review, then there's no longer any check on powers exercise. And a fifth source of arbitrariness is proportionality. That is the relationship of terms of reasonable relationship of means and ends. You think of sort of prosecution over tax investigations of Navalny in Russia, and then putting him in prison, ultimately where he dies. So now let's turn to IEL and think about the rule of law and how international economic law can contribute it from a problem-centered perspective. First, this is the primordial problem, recall, is when law is not applicable to the powerful. Today, we see how the problems arise not only internationally, but also domestically in foreign relations law. To turn to the United States internationally, the US, the world's most powerful country, effectively is taking the position that treaty commitments do not apply to it, whether they be multilateral, regional, or bilateral. And domestically, in terms of what we call foreign relations law in the United States, President Trump, the world's most powerful person, is using old laws with vague national security provisions to contend that he as president is not constrained by domestic law or the U.S. Constitution in setting tariffs at his whim. If one statute is foreclosed to him, he turns to another. In this way, the United States currently is undoing the international trade regime. It has upended the fundamental norm of most favored nation treatment for tariffs. It uses domestic statutes in protectional ways that are contrary to the statute's intent. It threatens and changes its tariff rates for different countries at the president's will, grudge, pique, or rage, making nonsense of the concept of binding tariff commitments. It has blocked the functioning of the dispute settlement system of the World Trade Organization to resolve disputes. The result is that trade law effectively no longer applies to the United States, the world's most powerful country. And this has huge implications for constituencies around the world, from the poorest and most vulnerable, Lesotho, which was subject to 50% U.S. so-called reciprocal tariffs, to Sri Lanka, where around a quarter of the population lives in poverty, which faced a threat of a 44% U.S., quote, reciprocal tariff, to Switzerland, which imposes no tariffs other than on agricultural products, but was to be subject to a U.S. reciprocal tariff because President Trump was piqued at the Switzerland's president following a Zoom call. There's a history to U.S. invocation of American exceptionalism, but not in ways that destroyed the post-World War II institutions that the U.S. was central to creating. Let's turn to the second source of arbitrariness, where the application of law is such that one cannot plan one's life because one does not know when law will be used against one. From a rule of law perspective, the law is to be published, prospective, consistently applied, not discriminatory, and reasonably stable. Law is to provide some certainty and predictability in a world that may otherwise be characterized by Hobbesian conflict and coercion. The provision of reasonable certainty and predictability is central to international economic law. Article 1 of the IMF articles includes, among the IMF's purposes, the need to promote exchange stability and maintain orderly exchange arrangements among members. Article 3.2 of the WTO dispute settlement understanding provides that the dispute settlement system of the WTO is a central element in providing security and predictability to the multilateral trading system. Security and predictability are also a central theme of trade and investment jurisprudence. Take, for example, a case in which Professor Weiler was a panelist, U.S. Section 301 case, brought by the European Union. I'll discuss it a bit more, but just to note, the panel stressed the importance of security and predictability, which affects mostly individual economic operators. The third source of arbitrariness is where there is no institutional machinery, where one can contest the application of law against one. The great advance after World War II was to create new institutions for the resolution of interstate conflicts, combined with a growing role for domestic courts and other independent institutional bodies around the world to resolve disputes. These institutions are important for checking the arbitrary exercise of power. At the international level, the neutering of the WTO dispute settlement system has undermined the ability of affected foreign stakeholders to hold states to account. Earlier, I wrote about how stakeholders could work with their governments in order to challenge foreign trade barriers that affected them in violation of WTO requirements. Although they did not have direct access to the system, affected stakeholders could work with states to defend their concerns. A fourth source of arbitrariness is where decisions are not based on reasons that can be contested. The WTO's agreements on, for example, sanitary and finitary standards and technical barriers to trade, they can be viewed in rule of law terms. They press states to be transparent, create national inquiry points, explain their measures before WTO committees, give justifications for them, and show that defend this evidence and listen and hear those who are affected adversely by them. This source of arbitrariness is becoming more salient as countries like the U.S. raise tariffs or block imports on national security grounds, while maintaining that their invocations of national security are self-judging and not subject to review. Claims of unbounded discretion to impose without having to give reasons other than declare the magic words, national security, undermine the rule of law. Because of this security, geoeconomic logic, national security bureaucracy's power has risen in China, the United States, and elsewhere at the expense of other ministries. National security officials' mindsets make them less likely to take account of rule of law concerns. The world risks becoming a less predictable, less cooperative, less peaceful one as a result. The fifth and final source of arbitrariness I want to address is where there is a lack of proportionality between sanctions and offense. The WTO dispute settlement system is based on proportionality regarding remedies. You can only if there is a violation, you can withdraw an equivalent level of measures of tariffs. Similarly, the WTO anti-dumping agreement and the WTO agreement on subsidies and countervailing measures respectively permit members to raise duties on dumped and subsidized goods, but only to offset the effect of the dumping or subsidy, up to a set amount. The aim is for the legal response to be proportionate. Today, however, once more, we see the United States wielding non-proportionate responses as when tariffs suddenly are doubled overnight from 25 to 50% at the president's whim. Take Brazil, when the president was upset of the Brazilian Supreme Court investigating the former president in an attempted coup that resulted in attacks on their Supreme Court, on their national parliament and presidential palace. So much of so that's the world of international economic law we face today. And its implications extend well beyond international economic law. So let me now address how can international economic law support the rule of law from a transnational perspective, since so much of it is about interstate relations. And I'm going to take as my example a start from a wonderful book, Ernst Frankel's book, The Dual State, a contribution to the theory of dictatorship, about law in Nazi Germany. And what Frankel stated was, I'm just going to read a brief quote, which I find quite fascinating, because this is not a book about international law. He says, the legal theory of post-war German counter-revolutionaries, the Nazis, was decisively influenced by international events and the concept which permitted an unlimited sovereignty to ignore international law, which is the source, that is the claim that they can completely ignore international law is the source of the theory that political activity is not subject to legal regulation. This was the presupposition for the theory of the prerogative state being the Nazi state, where it is the Nazis' prerogative to act where they wish of areas which they consider to be, quote, political. Now, when criticized, I just give an example about his treatment of Jews among other vulnerable groups. The Nazi position, this is during the League of Nations, focused on sovereignty. Joseph Goebbels, head of the Nazi propaganda ministry and advocate of the Holocaust, is quoted, possibly apocryphally, but there's evidence of going both ways. It's maintaining, we know he went to the League of Nations, and they're saying that these are, quote, our Jews, quote, our socialists, and not of your concern. A few weeks later, after Goebbels' visit, 9 months after Hitler assumed power, Germany withdrew from the League of Nations. The passage from Frankl captures my argument that there's a link between those challenging international constraints on powers exercised and the upending of the rule of law domestically. My argument is that attacks on international economic law institutions will operate in parallel with attacks on domestic ones. The rule of law is just likely to progress or recede in parallel at the national and international levels in virtuous or now vicious cycles. From this perspective, international law and international economic law are critical from a rule of law perspective in ways that intermesh with domestic contexts. International law and international economic law were important, I contend, in three broad ways. One, to facilitate peace and economic stability and security. Two, to develop, oversee, and indirectly shape norms that support the rule of law at the national level. And third, to provide direct international institutional review of violations of the rule of law. So let me look at each in turn. First, from a minimalist perspective, international law and institutions to secure international peace, which ultimately this affects international individuals and societies. No one's more at risk of power's arbitrary exercise than during times of violent conflict. Think then of the United Nations and the prohibition of the use of force except in self-defense or as authorized by the UN Security Council, and think about how that core norm is being violated today. Think, too, of the role of tribunals, international tribunals, in settling boundary disputes. So in the paper, we calculate that 53 boundary disputes were decided by the International Court of Justice and other international courts since World War II. States have complied with 85% of them. Now, there's nothing that is more likely to lead to war and violent conflict than boundary disputes. Just think counterfactually, if those international courts did not exist and states could not go before them and use them as a mechanism to go back to their own constituents and say, we did our best, and we lost. And we accept this result because of international law. Okay. Now, to turn to international law, we should ask, does it contribute to international peace and financial stability? And if so, how? And the WTO provides a legalized system for resolving trade disputes. Without it, trade wars are much more difficult to restrain, since tit-for-tat retaliation can lead to greater distrust and conflict, as evidenced by the tariff and currency wars of the 1930s. Among the aims of international investment arbitration is to resolve disputes over the treatment of aliens and their properties that earlier had led to armed interventions. Although the investment law regime is subject to significant critique from a rule of law perspective, at a minimum, the illegality of the use of force to protect citizens' property claims abroad represents a significant advance. So how to develop international economic law in order to ensure peace and stability ultimately is an empirical question. We could address this more in Q&A, but let me just stress that think about the European Union. I'm giving this talk from the European University Institute, which is a pan-European funded university. European integration advanced by Jean Monnet was about integrating Germany with the rest of Europe to foster a more peaceful Europe. Interestingly, Monet started his career in the economic division of the League of Nations, much of whose staff migrated to other organizations, including the newly created International Monetary Fund. Peace and stability should be an overall goal. It is more likely to arise if there is some sort of settled international economic law order, one that helps to resolve the Hobbesian problems of violence and instability that are arising once more. Second, indirectly, international law and institutions affect domestic rule of law practices in relation to individuals. Just think about the Helsinki Accord and its importance in Central Europe for providing hope for people there. Let me turn to international economic law. First of all, GATT Article 10 creates transparency obligations of all WTO members. Such obligations should both benefit domestic and international constituents. The publication of laws that are only prospective and they're subject to some sort of legal review and their application is essential to the rule of law. I mentioned earlier the panel's decision in the U.S. Section 301, and it focused on the indirect effect of WTO law and providing individual traders with certainty and predictability that without such law and such institutional ability to address legal claims, that these threats would have chilling effects on the economic activities, ultimately, of individuals. The panel stressed it'd be wrong to consider that the position of individuals is of no relevance to the GATT-WTO legal matrix. Today, of course, unfortunately, Section 301 is now being used as a pretext to reenact tariffs that the Supreme Court had found to be illegally imposed, and these investigations cover 99% of imports into the United States. Quite remarkable. Let me turn to one other famous WTO case, the U.S. shrimp turtle case brought in Asia by India, Malaysia, Pakistan, and Thailand. It shows the important indirect effect that international economic tribunals can play in supporting the rule of law at the domestic level. In that case, these 4 South and Southeast Asian nations challenged the U.S. ban on shrimp imports from countries that did not require certain shrimp trawling devices to protect endangered sea turtles, an important and legitimate aim. The WTO appellate body found that although the U.S. objective indeed was legitimate, and ultimately found over time, after the U.S. modified its practices, that they were compliant. But it found initially that the U.S. had failed to provide, quote, due process rights to other countries to defend themselves. It found that U.S. measures were arbitrary and that the process was not transparent or predictable. It did not provide any formal opportunity for an applicant country to be heard or to respond to any arguments that could be made of it. It did not result in formal, written, reasoned decisions. These are all quotes. They're all grounded in the rule of law. It offered no procedure for review or of appeal from a denial of an application. Now, what the appellate body did not address in this case, but I went to Thailand to research and actually went to the beaches and visited the shrimp trawlers, but it exemplifies why such provisions are important, is that thousands of small Thai shrimp farmers lost their investments from such sudden U.S. measure, which triggered a glut of shrimp on the market, a collapse in prices, which allegedly resulted in financial ruin and some suicides. Neutral international institutions, in other words, can press powerful states to take the views of the less powerful into account through independent domestic institutions with serious implications for their constituents. And then finally, international law can provide direct legal protections and legal accountability for individuals in support of the rule of law. We see this more in human rights law, such as the regional human rights courts outside of Asia. We see it less directly in terms of international economic law, but we see some places. We see it obviously in the EU. We see it in ISDS tribunals. And I could address, some of the challenges of them, but I do view that we should we should think about international investment law in terms of the different institutional alternatives for addressing and supporting the rule of law for all constituents. And I want to say a few words next just about, is international economic law an answer to contemporary rule of law challenges? The answer is yes and no, because no, I don't focus on simply compliance with the rules. It's very important to retain critique of the rules. They always can be improved. All law should be subject to critique. The rule of law, rather, is about constraints in the arbitrary exercise of power. And that means that international institutions, as well as domestic institutions, need to be subject to the rule of law. And so, example, to turn to investment state dispute settlement, as I've written before, one of the disconnects in this field is that proponents focus on the need for investment arbitration because of challenges with the domestic rule of law, while opponents focus on the failure of ISDS to adhere to rule of law standards. And so one needs to address the jurisprudence, the rules, and think hard about how to create the right balance. Then the question, is what to be done. I don't really have time. I think it depends on different contexts. But I do want to make 2 points. One is, and this goes back to the Biden administration. The Biden administration called for an alliance of democracies against China. And to me, although it's admirable to address the importance of democracies to get together to protect the rule of law, it's also dangerous. It's dangerous because, one, it risks creating new trade blocs, conflictual trade blocs. It results in potentially sort of empowering authoritarian nationalists domestically in China and elsewhere who view these alliances as a threat, expand their powers in defense of national security within their own jurisdictions. I have a forthcoming book on China about how this is developing with a Chinese colleague. It also risks if you divide the world into these opposing blocs, then we threaten the underlying Hobbesian task of securing order, enhancing trust, and supporting the conditions of cooperation to solve global problems. So if indeed national and international norms regarding the rule of law recursively interact, then responses to the current cycle must occur at multiple levels, including domestically, regionally, and globally. We cannot afford to turn inward. Here, let me just channel philosopher Kwame Anthony Appiah, who wrote, "As a populist demagogues around the world exploit the churn of economic discontent, the danger is that the politics of engagement could give way to the politics of withdrawal. Forgetting that we are all citizens of the world, a small, warming, intensely vulnerable world would be a reckless relaxation of vigilance. Elsewhere has never been more important." Today, the terms globalists and transnationalists are wielded as epithets, at times with good reasons, but we're ultimately all in this together. So I want to just end with 2 silver linings. Let me just start with a poem. As Professor Weiler knows, I'm a great fan of poetry, and this is just lines from a poem by one of my favorite poets, written in 1940, just after World War II broke. A poem by W.H. Auden. And he wrote, "Will time say nothing but I told you so? If I could tell you, I would let you know." I think we can still take hope from the following. First, we must not take for granted the important institutional developments, both domestically and internationally, that arose after World War II and the end of the Cold War. International and domestic institutions are under stress today, but we're better off in a world with them than without them, which was a world that characterized the interwar period before Auden wrote his poem. And second, history is replete with challenges to the rule of law because the rule of law always involves struggle. It always involves struggle because power is at stake and those in power question whether their power should be constrained. Pressure on the rule of law, as Martin Krieger writes, is not an anomalous contemporary defect, but a historically standard default. Working to uphold the rule of law, domestic and internationally, depends on us, just as it did on those who came before us, and just as it will on those who succeed us. Thank you very much.
Thank you very much, Professor Schaefer. I want to start the Q&A by the following question. And one of them is inspired by one of the questions in the Q&A.
Yes.
So it was never perfect. There were challenges to the rule of law, but the crisis today, at least in recent time, is pretty unprecedented. And the villain of the piece is the United States, disrupting both the institutional framework and the substantive framework, and by your pretty brilliant analysis, wholesale violation of these 5 principles of the rule of law. So the question has 2 parts. Do we just have to hold our breath till the end of the current American administration and then have hope that things will go back to normal? But in the interim, and this interests me, can you see a trajectory where the United States will have taken itself out of the system, will disrupt the system, but the rest of the world will just go on according to the normal rules of the WTO, at least panel dispute settlement, and trying to follow the framework that existed pre-Trump?
Yes. Thank you, Jeff. Thank you for the question. First of all, I think that the 2 things, just in terms of what do we do right now. One, I think it's very important to engage, and important to engage in multiple levels. So I'll just give one example. The Trump administration tried to impose the tariffs under what's called the International Emergency Powers Act. And that was held not to grant the requisite statutory authority. So now it has this interim measure on, quote, balance of payments grounds, but that expires after 150 days by statute. And now, in the meantime, it's in conducting Section 301 investigations. The Section 301 is a process that it's an expedited process. There's never been this many investigations, so they're clearly be done as a pretext. But it requires a notice and comment period. It's very important for countries to engage and to give comments. Singapore did, for example. In its notice with respect to the Section 301 investigation against Singapore, it made a mistake by stating that the United States had a trade deficit with Singapore. In fact, it has a trade surplus. Well, that's very important for arbitrary and capricious review, because if the United States is rushing with all these procedures and makes such basic factual errors, right, then it's subject to at least a successful domestic challenge. No one initially thought that the courts would not defer to Trump on Section 301, but now it's a real question. So if you want to protect the international institution, a lot depends on what's happening in the United States domestically, including with courts today. And so I'm writing something on Section 301 right now, providing grounds of why these investigations are purely protectual and unlawful. Then about the second part of this, I believe, is about the rest of the world. Will it just go on, or will the United States leave the WTO? In my view, the WTO effectively has left the WTO. It hasn't formally left the WTO, but it has effectively left it. It's not willing to adhere or recognize or even speak about any WTO rules. So it's just a charade. I mean, people are happy that when the Trump administration withdrew from dozens and dozens of international institutions, the WTO was not one of them. So there were people within the U.S. administration that clearly said, no, we should not formally withdraw from this. And that's a good thing, I think, potentially for the future. But you should recognize the U.S. effectively is not not paying any attention to the WTO, its rules, or its institutions. So, should the rest of the world just go on without it? Well, yes, it should. In my view, it more or less already is. We see this. There's more that could be done. Let me just say a few words about that. And let me also say a few words about the risks of this. I mean, if you look at sort of rule of law developments domestically around the world, they're in decline. They're in decline in India, they're in decline. They were in decline in Brazil and could be again. We will see, right? But these are across all indexes, right? And this has something to do with the rise of populism. It takes different variants in different countries. But it's happening. And so there will be pressure in those countries that those who are autocratically in power, they don't like constraints. They don't want domestic constraints. They don't want international economic law constraints. So that is a risk today. If we see these rule of law trends declining around the world, the risk is what we're seeing happening with the United States will happen with other countries. But for the time being, other countries are being coerced to violate WTO rules by the United States, such as the most favored nation treatment, by granting 0% tariffs to U.S. imports into their countries in exchange for only having 10, 15, 20%, what have you, tariffs applied by the United States with certain carve-outs on their exports. That's the game. But I think that we're so far, it's been good to see that countries generally appear, and you see this by declarations by the BRICS countries and others, of the importance of the WTO system. So that has happened so far, and I hope it continues. But more could be done. For example, you have what's called the European Union was fundamental in creating an interim mechanism for resolving disputes, sort of like an ad hoc arbitral, it's sort of a form of an arbitral body, more form of an appellate body to resolve trade disputes. You could see more countries joining this and using this amongst each other. And so more can be done institutionally to support that mechanism by Korea could join and so forth. I'm sure the United States will put pressure on them not to do so. But there's a concern. I've heard this when I've spoken with Indian diplomats that one of the problems is that, although my own view is that one of the problems is that if there's a ruling and they comply with that ruling, such as a ruling against a subsidy or a local content restriction, if they then comply with that ruling, they suddenly have an asymmetric compliance vis-a-vis the United States. So the United States can give the same subsidies, the same local content restrictions, so it puts them at a disadvantage. So it's not an easy solution, right, to go this multilateral route without the United States in practice. But it's the best alternative, in my view, that now exists.
So the following question is a kind of subtext of several of the questions in the chat. I want to take you to the pre-Trump era. Yeah. And it's not as if the international economic system in general and WTO was a bed of roses. The Doha Round has been moribund for more than 20 years now, etc. And there are many culprits or many stakeholders which have prevented that. And part of the reason for that, you might agree with me, is that the international economic system, the GATT, its successor, was very much a Western creature, a Northern creature. So if we set aside the current crisis, do you think that the international economic system has been sufficiently successful in bridging the North-South divide, in mediating the almost structural inequities that exist in the current system, which, to go back to my beginning, is part of the explanation for the moribund Doha Round, etc.?
Yes. Yeah, I mean, the way everything you said is correct, Joseph. The way I think about all of this is that there's no institutional nirvana, and there never will be. Power exists in the world. It's the way the world is. It's no surprise that this was a sort of Western European creation. Um, whatever will exist in the future, powerful actors were going to have a greater role in creating it. The question then, and much of my work during this period of time was to work with different countries to build legal capacity, to use the rules and to use the system. And many did. You saw, I mean, even Bangladesh, I did a couple of books on this, including the Emerging Powers book. But Bangladesh, for example, successfully brought a case against India, right? It was something that would not be thought of otherwise, very weak and was very dependent, including the prior regime, right, on India. And so over time, that those who call them the sort of less powerful, the have-nots, they can learn to use the rules, right? And a lot of the rules, frankly, were pretty good rules. The most favorite, non-discrimination rules, fundamental rule. TRIPS, obviously, IP rights was much more problematic, but it actually, in practice, didn't operate in such a fashion as compared to what was happening when the U.S. was putting unilateral pressure on countries in prior years. But yeah, so there's lots to critique, and many of us were engaged with critiquing. But I think the core GATT, most of the disputes were GATT-related disputes. They created committees, where everybody could have a voice. The problem was structural, as you noted. The problem was, some countries may have one person in Geneva and they can't fly people, from Brussels to Geneva, or, to be able to prepare and participate in every committee and every dispute. But that's going to exist in any institution that you create, whatever the rules. I mean, that's just personnel, knowledge, capacity building challenges. And so then one has to think about different ways to address that challenge. And to address that, you can think about creating Global South think tanks, which was done. You can think about, creating an advisory center for bringing disputes, which was done. So there was a lot done to try to enable countries to use the system more effectively. And in my book, I say, unfortunately, arguably, this is one of the reasons why the U.S. turned away from the system, because other countries were actually learning how to use it against the United States to constrain the exercise of U.S. authority, right? So I think that, it's not just the rules and the institutions. So much of it is building sort of the legal capacity to use them, whatever they may be.
I have one last question, because unfortunately, all good things have to come to an end. Refreshingly, there was one theme that you did not pick up in your lecture, and that's the huge role that technology, platforms, the internet, social networks, X, Twitter, Instagram, TikTok, etc. Does this kind of technological revolution, which in some ways even brings the world more together than before, is it at all relevant to the themes that you have discussed? And this is inspired by one of the questions in the chat.
Yeah, wonderful. No, it's certainly the cutting edge of thinking and this sort of new generation of scholars who are going to succeed us. It's so important. Obviously, it provides real opportunities in terms of access to information, which is can benefit everyone. People having access to public infrastructure to provide this information. That provides real advantages. I'll just say a word, though, about a concern I have, and it's actually because it's the subject of a new project I have, and that is this turn to geoeconomics and strategic autonomy and so forth. And I mentioned this right at the start of the lecture. And that is you see new think tanks, you see a rise in scholarly publication. It becomes the logic, it becomes the dominant frame of analysis. So I just recently plugged into a search engine, what is the dominant frame today for understanding international economic relations? And it wasn't law, it was geoeconomics, right? the more we repeat this and the more we go to AI to get knowledge, to understand the world, if it becomes embedded in AI, it becomes the truth. In other words, this frame entraps us because AI reproduces what's out there happening, and then suddenly it's the only way to see the world. And of course, as I said, geoeconomics, this whole logic, this frame that we exist today, has nothing to do with the rule of law. And that's the other challenge is it produces. So we need to use it, but we also need to be wary of it.
I'm afraid we have to end. I think I speak for the almost 100 people who have been attending the webinar. Thank you very much for a splendid lecture. Thank you.
Thank you, Joseph. Yes.